Hello class, so this is our lecture for the Trust Receipts Law or Presidential Decree 115. The first thing you need to know when studying this special law is to know what a trust receipt is. So this is a written or printed document, and the parties to this document is called the entruster and the entrustee. So this is signed by the entrustee, and it is constituted in favor of the entruster, and this contains terms and conditions which substantially complies with the provisions of PD 115. So this document evidences absolute title or security interest of the entruster over the goods. So under the law, there is a prescribed form for a trust receipt. It must be written or printed. No other formality is required, so therefore it does not need to be notarized. And in PD 115, the contents of the trust receipt are prescribed, and there are several contents. First, it describes the goods, documents, or interest, which is the subject of the trust receipt. There must be a value or the total invoice value of the goods and the amount of the draft that must be paid by the entrustee. There must be a specific provision, which is an undertaking or commitment of the entrustee to hold in trust for the entruster the goods, documents, or instruments, and to dispose of them in accordance with the purposes provided in the trust receipt. And lastly, there must be an undertaking that the entrustee will turn over the proceeds of the sale of the goods, documents, or instruments to the entruster, to the extent of the amount owing to the entruster or as appears in the trust receipt. And in the event that the goods cannot be sold, then the entrustee must return those goods, documents, or instruments to the entruster. So it also contains the terms and conditions as agreed upon by the parties. And as long as it is not contrary to law, morals, or public order, it can be stipulated in a trust receipt. So a trust receipt, guys, it is another kind of security or secured transaction. And this is another financial device that will aid importers and retail dealers, especially those who do not have enough funds or resources to finance the importation or purchase of merchandise. And they may not be able to acquire ready credit from banks except through using as collateral the merchandise that they will be importing or purchasing. So do you get the nature of this transaction, guys? You are a businessman or businesswoman, and you need to import or purchase certain goods, but you do not have capital or resources or funds to purchase or acquire those goods through a straight sale. So what you do is you will need to enter into an agreement. It could be a bank or any other financial or lending institution, and that lender will extend to you the money needed to purchase or import the goods. But in order to secure that particular loan or that particular borrowing, then you need to execute a trust receipt in favor of the lender or the creditor. So this trust receipt, guys, it's in the nature of a chattel mortgage, but it's really different because this kind of financial instrument will impose obligations upon the entrustee that if the goods cannot be sold, then the entrustee will have to return the goods to the entruster or whoever has extended the credit to the buyer or importer. So it is a method of financing importations or financing sales. So the nature, therefore, of a trust receipt transaction is that it is a security transaction. It secures an underlying obligation like a loan. And it has two distinct features. One is the loan feature and the other is the security feature. Any violation of the twofold obligation by the entrustee, which is to remit the proceeds or to return the goods in the event of non-sale, will place the entrustee liable for violation of PD 115. And this is a malum prohibitum offense. The entrustee will be liable for prosecution for estafa. So how do we distinguish the trust receipt transaction with other kinds of related contracts? So unlike a pledge, guys, when you pledge a thing, you have to surrender its possession to the pledgee. However, in a trust receipt transaction, the person who finances the importation or purchase will possess the property. Not the person who finances, but the person financed, okay, will end up possessing the property. So that's why it's important to impose the twofold obligation on the entrustee. How about a trust receipt transaction and a conditional sale? So in a conditional sale, there is a sale of property from the seller to the buyer. But in a trust receipt, there is no such sale of the property from the entruster to the entrustee. In a chattel mortgage, it will involve creation of alien upon the property. However, the trust receipt will not involve creation of alien on the goods, documents, or instrument, which is the subject matter of the trust receipt. Because in fact, the entrustee is obligated to sell whatever is the subject of the trust receipt. And lastly, the difference between trust receipt transaction and a consignment is that in consignment, the consignor will retain title to the property to secure the indebtedness due from the consignee. Therefore, it is bipartite in nature. But in a trust receipt, the seller will not retain title to the property, but can actually transfer title to the entruster. So there is a tripartite relation. So even if this was the trust receipt transaction is designed for import or importation, it can also apply to domestic transactions. So regardless of whether the transaction is foreign or domestic, it is important to note that the transactions discussed in relation to trust receipts mainly involve sales. So it covers sale transactions that are purely domestic. This is pursuant to the ruling in Nang versus People. Is PD 115 applicable to commission merchants or those who sell on commission, meaning they are not the absolute owners of the property, but they are acting in behalf of the true owner and they will earn commission for every sale made? Can this be made applicable to commission merchants? So in the case of Damian Robles versus Court of Appeals, PD 115 can be made applicable to commission merchants. So the defense invoked here is that there was no trust receipt transaction, but in fact, there was ordinary sales on trial basis. Okay, guys, so this is now the classic definition of a trust receipt transaction. And let me give you a tip, huh? You need to memorize this definition, because if you have this definition implanted in your head, guys, if you encounter any question about trust receipts, you'll be able to answer it. Trust me. Okay? So for this topic, you have to memorize the definition of a trust receipt transaction, because it is really the essence or the gist of the entire law. Okay? So let's read it. So what is a trust receipt transaction? It is any, take note of the word any transaction by and between the entruster and entrustee, whereby the entruster who owns or holds absolute title or security interest over certain specified goods, documents, or instruments releases the same to the possession of the entrustee upon the latter's execution and delivery to the entruster of a signed document called a trust receipt, wherein the entrustee binds himself to hold the designated goods, documents, or instruments in trust for the entruster, and to sell or otherwise dispose of the goods, documents, or instruments with the obligation to turn over to the entruster the proceeds thereof to the extent of the amount owing to the entruster, or as appears in the trust receipt, or the goods, documents, or instruments themselves if they are unsold or not otherwise disposed of, in accordance with the terms and conditions of the trust receipt. So it is quite lengthy to memorize. So I suggest that you break it down into its important clauses, and that's what we are going to do in the subsequent slides. But the key concepts that must be captured in your definition of a trust receipt transaction is that it must first mention the parties, which are the entruster and the entrustee. And the entruster here, who is considered to have absolute title or security interest. Okay, those are keywords: absolute title or security interest over specified goods, documents, or instruments. Don't forget this, guys, kaning subject matter of the trust receipt, which is the GDI, goods, documents, or instruments, whereby the entruster releases the same to the possession of the entrustee upon execution and delivery to the entruster of a signed document called a trust receipt. Okay, so that's the first clause. The second clause is that you have to mention in your definition the obligation of the entrustee, which is to bind himself to hold the designated goods, documents, or instruments in trust for the entruster or not or and to sell or otherwise dispose of the goods, documents, or instruments with the obligation to turn over to the entrustor the proceeds thereof. Okay, so don't forget this, guys, the important clauses. That will be the parties and what the entrustor will have to do, perform, which is to release the goods. And on the part of the entrustee, he will have to execute and deliver it the trust receipt. The second clause of the definition is the obligations of the entrustee. So that must be mentioned in your definition of a trust receipt transaction. Okay, guys, so you just learned of the definition of a trust receipt. And in that particular definition, you know that the purpose of the releasing of the goods, documents, or instruments to the entrustee is for him or her to later on sell those. But Presidential Decree 115 actually authorizes the release of the goods, documents, or instruments for several purposes as well. So if the subject of the trust receipt are goods or documents, then it can be the purpose of the release to the entrustee can be to sell the goods or procure their sale, to manufacture or process the goods, but still with the purpose of ultimate sale. And another purpose is to load, unload, ship, or transship, or otherwise deal with the goods or documents in any manner which can be preliminary or necessary to a sale. So let me emphasize that ultimately, the goods or documents must be disposed for sale. If the subject matter of the trust receipt, however, are instruments, then the purposes for the release to the entrustee will also be to sell or procure its sale, to deliver the instrument to a principal, to effect the consummation of some transactions which still involves delivery to a depository or register, or to effect the presentation of those instruments or its collection or renewal. And this is in accordance with Section 4 of Presidential Decree 115. So there are transactions expressly excluded by PD 115, and this is illustrated in the case of De La Cruz versus Planters Products Incorporated. So in the event that the sale of the goods, documents, or instrument is made by a person who is in the business of selling such goods, documents, or instruments for profit, and this person at the outset of the transaction has, as against the buyer, general property rights in such goods, documents, or instruments, or who sells the same to the buyer on credit, and this person, the seller, retains title or other interest as security for the payment of the purchase price, then their transaction will not constitute as a trust receipt transaction, and it is outside the purview of PD 115. So as an aid to you in learning the elements of a trust receipt transaction, there's a mnemonic for that, guys. And it's PISOT. Okay? So first we have parties involved. That's the entrustor and the entrustee. Then I for issuance of the trust receipt by the entrustee, which is made prior or simultaneous with the release of the goods, documents, and instruments by the entrustor. So it is the entrustee who will issue the trust receipt, and it is the entruster who will release the goods, documents, or instruments. Then S stands for subject of the trust receipt. So the subject of the trust receipt is GDI, goods, documents, or instruments. Then O stands for obligations of the entrustee and the nature of the entrustee's possession. So remember the twofold obligations of the entrustee. Diba? And T stands for title and interest of the entruster. So keyword here is that the entruster has absolute title and security interest over the goods, documents, or instruments which are specified in the trust receipt. So pisot. Don't forget that. Okay, so parties involved, again, they are the entruster and the entrustee. So the entruster is the one in whose favor the trust receipt is constituted. So this refers to the person who holds title over the goods, documents, or instruments, and includes any successor in interest of the entruster. So the entruster is entitled to the proceeds from the sale of the subject of the trust receipt transaction, and if not sold, to its return. On the other hand, the entrustee, this is the one who issues the trust receipt. And this is the party who takes possession of the goods, documents, or instrument under the trust receipt transaction. And it includes any successor in interest of the entrustee. So the entrustee is the merchant, the importer, or the retail dealer who uses the financing facilities of the entruster to acquire the goods, documents, or instruments. And the entrustee is the one to whom the merchandise are delivered for sale or processing for sale, and is the one who bears the risk of loss. Now, in practice, guys, even though it is the entrustee who will issue the trust receipt, kaning si entruster, they actually have this pro forma trust receipt na template. Okay, so legally, we understand, however, that since the entruster is actually the obligee in this transaction, kay the entruster is the one in whose favor the trust receipt is constituted. However, in practice, si entruster gyud ang tig provides trust receipt form. Yan, mopirma lang si entrustee. So what's the trust receipt transaction process? Okay, first, the entrustee must execute the trust receipt and deliver it to the entruster. Then, after execution of the trust receipt, the entruster will then release the goods, documents, or instruments to the entrustee. Upon that happening, guys, then that's the time when the twofold obligation of the entrustee will arise. So remember that there is an underlying transaction in a trust receipt transaction, and that is essentially a loan. However, we must make a distinction between a contract of loan or mutuum and a trust receipt transaction. So in the event that the possession of the goods subject of the trust receipt is already with the entrustee, even before the execution of the trust receipt, then we consider that as a simple loan. It will not come within the purview of a trust receipt transaction. So this principle is illustrated in the case of Colmenares versus Court of Appeals. So in this case, the so-called entrustee actually had in possession already the goods, which were construction materials. And considering that the entrustee, the so-called entrustee, did not acquire possession after execution of the purported trust receipt, in that case, then it was not considered as a trust receipt transaction, but only a simple loan. Okay, so what can be the subject of trust receipt transactions? You know this already, GDI, goods, documents, or instruments. By goods, we understand that as being chattels or personal property other than money. It can other than money or things in action or things that are affixed to real property. Documents refers to written or printed evidence of title to goods. And instruments actually refer to any negotiable instrument as covered by the negotiable instruments law. So this could be certificates of stock, bonds, or debentures. So instruments as defined in PD 115 will not include documents as defined in the same law. So lahig yun ang treatment. But in the civil code, we just understand this as things in action, di ba? Or intangible personal properties. Okay, so another important concept is ownership of the subject of the trust receipt transaction or ownership of the goods, documents, and instrument. So remember that ownership pertains to the entruster. So typically, an entruster is a bank. And the bank acquires security interest in the goods as holder of a security title for the advances it made to the entrustee. So the ownership in the goods, documents, or instruments continues to be vested in the entruster who has made advance payment until fully paid. And if the merchandise or the goods has already been sold, then the proceeds of the sale should be turned over to the importer or the entruster or the representative of those parties. So this is a requirement of PD 115 in order to secure the payment made by the entruster. So full title to the goods is vested in the entruster from the very beginning of the transaction. And this title continues as indispensable security until the goods are sold and the proceeds of the sale are remitted to him. Or if not, there is no sale, when the goods are actually returned to the entruster. So in a case, guys, the Supreme Court characterized the nature of this transaction as partaking of a conditional sale, where the importer becomes the absolute owner of the imported merchandise as soon as he has paid the price. So question, does Presidential Decree 115 include goods that are intended for manufacturing? Because you previously learned that the purpose of the release of the goods to the entrustee is ultimately to have those goods sold or processed for sale. So can a trust receipt have as its subject goods that are intended for manufacturing or raw materials? And does the penal provisions of PD 115 apply when the goods are not part of the finished products, which are ultimately sold but instead, it is utilized or used up in the operation of the equipment and machineries of the entrustee manufacturer. So, not raw material, but it is used to operate equipment, and it did not end up as an ingredient of the finished product that is being sold by the manufacturer. So, covered ba siya sa trust receipt law? So, illustrative case for this is DBP versus Prudential Bank and Allied Banking versus Ordonez. So, in the DBP case, trust receipts covering imported articles which were installed in the machinery of the textile mill of the entrustee was recognized to be a valid trust receipt transaction. In the Allied Banking versus Ordonez case, wherein trust receipts were executed by a company engaged in the manufacture of steel and steel products, it was held in that case that the goods covered by the trust receipt, which were dolomite beach sa Manila Bay. So the goods covered by trust receipts were dolomites and nozzle bricks. And this dolomite were used for patching over the surface of furnaces, while nozzle bricks, which are insulating materials in the lower portion of the ladle. So part of the machinery in that steel plant. So ultimately, the goods subject of the trust receipt transaction, the dolomites and nozzle bricks, did not form part of the steel product. However, the court still found that the penal provisions of PD 115 were found to be applicable to the trust receipts transaction. So DBP case was decided in 2005, while the Allied Banking versus Ordonez case was decided in 1990. But these two cases have already been abandoned. Anong ibasa ni mo attorney kaskasa tag time? So what's the new rule then? The prevailing doctrine is that promulgated in Colinares versus Court of Appeals, Nang versus People, and Land Bank versus Perez. So in the Colinares versus Court of Appeals case, mo ni siya ang very issue of the case. Can materials intended for construction of a monastery be the subject of a trust receipt transaction? So Supreme Court said no. The petitioners, who were the entrustees, were not considered as importers acquiring the goods for resale. And that's contrary to the express provisions embodied in the trust receipt. They are actually contractors who obtained the fungible goods. Remember what fungible goods are? In order to enjoy these kinds of goods, you have to consume it, like food. So the functionality of that particular thing can only be consummated if it is consumed or devoured. So fungible gid siya. Being materials for a construction project, at no time did title over the construction materials pass to the bank, which was the entruster, but directly to the contractor CM Builders Center. So the transaction really between the parties was just a simple loan, and the trust receipt was executed only to secure payment of the loan. But it is not a trust receipt within the ambit of Presidential Decree 115. Yeah, take note that in this case, the entruster ended up executing affidavits of desistance for prosecution sa PD 115. So Colinares, the doctrine in Colinares has been applied in several cases involving kaning contractors construction contractors. So the practice of the court, in fact, even cautioned that the practice of banks making borrowers sign trust receipts to facilitate collection of loans and place them under threats of criminal prosecution should they be unable to pay is unjust and inequitable, if not reprehensible. Such agreements are contracts of adhesion which borrowers have no option but to sign, lest their loan be disapproved. So the Colinares doctrine has been applied in case of Consolidated Bank and Trust Corporation versus Court of Appeals, decided in 2001, and this involved bunker fuels used for a cement plant. So the same principle was applied. So gihimong subject sa trust receipt ang bunker fuel. But bunker fuel, another kind of fungible good, maoy mo fuel sa mga equipment. So it does not come within the ambit of PD 115. So remember that important concept, guys, as decided in case law. Because in order for you to answer this bar question from the 2013 bar year, you need to remember that. Okay, another issue resolved in the case of Nang versus People is, can chemicals and metal plates intended for the fabrication of communication towers be the subject of a trust receipt transaction? Supreme Court held again that no, the goods were never intended for sale, but for use in fabrication. The entrustor knew that the petitioner was neither an importer nor retail dealer. It should have known that the said trust receipt agreement could not possibly apply to the petitioner. So there was only a simple loan. Another case, can cement, bolts, and reinforcing steel bars intended for the construction of the Metro Rail Transit Project and the Clark Centennial Exposition Project be the subject of a trust receipt? Again, the Supreme Court held no. So in all trust receipt transactions, both obligations on the part of the trustee exist in the alternative, the return of the proceeds of the sale or the return of the or recovery of the goods, whether raw or processed. So when both parties enter into an agreement, knowing that it is impossible to return the goods subject of the trust receipt, it's not legally possible anymore. It has already been transformed, or it has already been affixed into real property. Then it is not a trust receipt transaction as penalized under Section 13 of PD 115. So in essence, the only obligation actually agreed upon and validly agreed upon by the parties would be the return of the proceeds of the sale transaction and not the return of the goods itself. And this transaction therefore becomes a mere loan, where the borrower is obligated to pay the bank the amount spent for the purchase of the goods. So the consequence therefore, guys, if there is a finding that there was only a simple loan and not a trust receipt transaction, is that the entrustee will be relieved from criminal liability, but however continues to be liable to pay for the amount loaned. Okay, so 2007 bar, this was asked, and you can answer this by applying the Colinares ruling. So therefore, it is now clear that construction contractors are not covered by trust receipt transactions. So read the case of Land Bank versus Perez. Okay, so equivalent trust receipt transactions involving goods and documents, and trust receipt transactions involving instruments So laylahi ang purpose of the release as previously shown earlier. So if instruments gani, we're talking about instruments covered by the negotiable instruments law, na siya'y purpose that it will be to deliver that instrument to a principal to effect the consummation of some transaction involving delivery to a depository or register, or to effect the presentation, collection, or renewal of that instrument. But goods and documents gani, it conforms to what we have been discussing, okay? That its purpose is ultimately to have the goods or documents sold. Is there a difference between a letter of credit and a trust receipt? Okay, we already discussed LC transactions. And we're discussing now trust receipt transactions. So yes, na-adyo distinct difference. However, in one transaction, guys, the letter of credit and the trust receipt can be used as financial devices to secure the obligations of the parties. So, you fuse ang LC and TR. So this arises when the transaction is not a pure trust receipt transaction, as when the entruster does not actually own the goods, but will only finance the acquisition of the goods. So a letter of credit trust receipt arrangement is endowed with its own distinctive features and characteristics. And under this setup, the bank will extend a loan, and this loan is covered by an LC. So pwede mo draw upon the LC. And the trust receipt is executed as security for the loan. So when a transaction involves a loan feature represented by the LC, well, the security feature is covered by the trust receipt. Then we have an LC-TR arrangement. So read the case of Vintola versus Insular Bank of Asia and America. Okay, this is the illustrative case for this kind of arrangement. Right, so let's find out now how reimbursement works in a trust receipt transaction. So remember, there is a seller and there is an entrustee / importer, or one who we consider as the buyer of the merchandise being sold by the seller. So between them, there is a contract of sale. So the seller, if he is not the absolute owner of the goods or not yet the owner of the goods, will need to apply for a letter of credit with the entruster, which is typically a banking institution. So between the seller and the entruster or bank, there is an underlying letter of credit transaction. So the entruster or the bank and the entrustee or importer or buyer, as between the two, there will be a trust receipt agreement reimbursement. Okay, the entruster will finance the acquisition of the seller of the title of the goods, and that financing will be covered by the LC. And this entruster of the bank or the bank will then be considered to have absolute title or a security interest subject matter of the trust receipt that will be issued by the entrustee. So the entrustee, upon issuance and execution and delivery of the trust receipt, will then be entitled to possession of the goods. So the seller will then release the possession to the entrustee. Okay, so just like the LC transaction, guys, you can see that there are complex contracts and relations between these parties. So remember that there are antecedent acts in a letter of credit and trust receipt transaction. The antecedent act in a trust receipt transaction will consist of an application and thereafter approval of the letter of credit, the making of the marginal deposit, and the effective importation of the goods through the efforts of the importer or the entrustee. So 2016 bar question, you are asked to explain what is a letter of credit as a financial device and a trust receipt as a security to a letter of credit. So it's important for you to understand that concept. Okay, this may well be asked in your bar here. So rights and obligations of the parties. So the entrustor has rights. Kay siya actually ang obligee in the trust receipt transaction. The rights of the entrustor are found in Section 7 of Presidential Decree 115. So in addition to the in addition to what you've already learned, that the entrustor has absolute title and security interest over the goods, and he has the right to the proceeds of the sale if sold, or the right to the recovery or return of the goods if not sold. The law also confers on the entrustor the right to enforce the following. The entrustor can cancel the trust and take possession over the goods, documents, or instruments at any time upon default or failure of the entrustee to comply with any of the terms and conditions of the trust receipt. The entrustor himself or herself or itself, a bank money typically, can sell the goods, documents, or instruments at public or private sale. And this sale must be not less than 5 days after serving or sending of notice to the entrustee of the intention to sell. The entrustor can also purchase the goods, documents, or instruments at a public sale held for that purpose. And the entrustor can furthermore recover deficiency from the entrustee should the proceeds from that public sale or private sale be insufficient. Okay, so security interest of the entrustor means property interest in the goods, documents, or instruments to secure performance of some obligations of the entrustee or of some other third person. So this includes title, whether or not expressed to be absolute, whenever such title is in substance taken or retained for security only. So keyword you guys, don't forget this. Ang nature sa ownership ni entrustor is absolute title and security interest over the specified goods, documents, or instruments. So what is the role of the entrustor with respect to the contracts entered or executed by the entrustee? Na naman niyang possession, di ba? So unsay labot ni entrustor kung mo-execute og other contracts si entrustee with third persons. So this will not affect the security interest held by the entrustor. The entrustor holding a security interest shall not, merely by virtue of such interest or having given the entrustee liberty of sale or other disposition, can be made responsible as principal or as vendor under any sale or contract to sell made by the entrustee. So although naay absolute title si entrustor, he is not privy to any contracts entered into by the entrustee and cannot be made liable as principal or as seller. So the validity of the security interest of the entrustor as against creditors of the entrustee or even innocent purchasers for value. So it is valid as against all creditors of the entrustee. So himo jud na enforceable ang security interest of the entruster despite the intervening transfers or dispositions of the subject of the trust receipt. Magukod gyud ni entruster wherever that goods end up, and you cannot invoke the concept of innocent purchaser for value. So what is the effect of non-compliance by the entrustee? Of course, there is criminal liability under both Presidential Decree 115 and the revised Penal Code. And there is civil liability for damages under Article 33 of the Civil Code. And in this instance, there is no need to prove intent to defraud because it is made as malum prohibitum by PD 115. What if the entrustee will be able to fulfill the twofold obligations even though it is beyond the period prescribed in the trust receipt? So we must make a distinction if criminal charges have been filed yet or not. Because if na-fulfill ni entrustee, meaning gi-remit niya ang proceeds of the sale or gi-return niya ang goods, then before criminal charges are filed, there will be no criminal liability. So gitagaan siya opportunity to perform the twofold obligation. After charge, but before conviction, there can also still be extinguishment of criminal liability. So the liability of the entrustee accrues upon failure to comply with the obligation to return. So it is not incumbent, therefore, on the entruster to immediately cancel the trust and take possession to be able to enforce his or her rights under the trust receipt law.